Carmen handles the west areas, south areas, and central areas of the city and Harvard. So she's the regional advisor for neighboring councils in those areas. To my left is Deputy City Attorney Lois Phillips, and Lois handles the valley areas and the east areas of the city. So she's the regional attorney assigned to those areas. To my far left is a colleague of ours in our office, and that's Phil Lamb. And Phil works in intellectual property, on intellectual property issues. After I'm going to do just a brief introduction, and then I unfortunately have to leave, so I'll be leaving this venue for preparation on another item. But we're going to cover a couple issues. Beginning with Phil, we'll start with some just trademark issues, a brief overview of things that we need to know, and then we're going to get into maybe some Brown Act issues, and then an open question on any questions or concerns that we might have. I do want to preface that today is it's an informational event. So the discussion or topics here, it's not considered legal advice. This is to provide you with a foundation so you have an understanding of the legal issues. If neighborhood council board members have any legal questions, then hopefully this will give you a background to follow up with our office so that we can provide that answer to you. Obviously, the answers are context specific, so it depends really a lot on the facts and circumstances of any given situation. So again, with that in mind, we want to provide you with the informational basis, but again, I'll tell you that the information provided during the course of this presentation is not legal advice. So again, thank you everybody for showing up. I'm gonna and also if anybody is interested, the next the sessions that I'm doing after this are the ethics training. So if you are interested or have never even had the in-person training in ethics, I would recommend that you attend those sessions to get a background here. The in-person training is very different from the training that you might receive online, because we dedicated and we really designed the course so that it addresses neighborhood council issues, so that you can see in a more easy, readily manner how these issues may impact you and the decisions you make on the board. We're going to go to Phil's. The ethics training? The ethics training is 1770. Room 1070. There's two sessions. One, the first session will start at 11 o'clock. That'll go 11 to 12. And the second session will be the first session covers the Political Reform Act, Government Code Section 1090, and the common law bias. They deal really with the bulk of the ethics issues. The second part of the course deals with kind of these other rules, like Brown Act, Public Records Act, some other small conflict issues, but the majority of the conflict issues is the first session. Thank you. Thanks, everybody. I hope I see some of you in the ethics course as well.
All right, we're folks following in, and if you can take a seat in the back, it would be great. I think we are a little short on time. Can you hear okay without a microphone, or better with a microphone?
With.
All right, we'll do that. As Darren introduced me, I'm Phil Lamb. I'm the elected property counsel for the office. It's kind of like a specialty counsel, like the digest to the all the general doctors here. I've been serving with the neighborhood council for years, since day one. In fact, all your logos for the neighborhood council was the one that I pushed for the city council to ask you all to design one and stake it to deal with the branding. I was just going through this. I want to make sure that you're here. There are a lot of good competing issues in here. This is the legal issues. Are you all here for the legal issues? Raise your hand if you are. I want to make sure you're all the legal right order here. Okay, all right. Because there are a lot of competing sections here. I'm just going to, by the way, in general, intellectual property covers a wide range of law. And they're kind of like different laws that put together in a bucket. And patent, you heard about all the patent. Anyone watch Shark Tank? Okay, all right. Okay, do you have a patent? So it's really the patent, so design patent? Yeah, those kind of things. But you probably won't deal with too much of that, so I won't talk much about it. But another bucket of the law will be trademark, and there will be logos, brand names. Think of Nike, your own logo from the Neighbor Council. That's your trademark. Okay, the name of the Neighbor Council exactly the same. It's your trademark. All right. And the third bucket would be copyrighted materials, which would be, I would have to give you examples for it, like photos, audio, visual, videotape, audio tape. There's a lot of things you can get off the internet. And by the way, just because they're free, it's not you can use it for free. Okay, often your favorite advice, division lawyers or lawyers, if you can use it for your official materials. And the last one, kind of related to the AV material, audio visual material, would be the use of likeness. We all have a right to our likeness, voice, the image, not to be used in a commercial way, unless we give permission. So if someone's taping right now and using my likeness in conjunction with a comics or advertisement, that person needs to get my permission before using my likeness. Or else he or she will violate my personal right. It does not matter if I am a celebrity or not, which I'm not. And we all have the same rights. And so that's the one part. Okay, so let me go into the trademark, the copyrighted material, and the license. The trademark, we talked about anything you use. Usually it's a logo or name to distinguish your service. So, automobile, think about it, how many automobiles out there? If you don't look at the logo, you cannot really tell what brand that is. I mean, think about it. If you don't look at the logo, I mean, just the design and whatnot. But as soon as the logo popped up, oh, it's got a certain quality to the car. So that is the essence. That is the essence of trademark, because the public seeing the logo or the name would associate the quality of the provider of service or goods. Right? So when they see the logo from the Neighbor Council, they say, okay, I know there's certain credibility that the Neighbor Councils put in and work put in. If they recommend certain program, certain logo, I know there's a certain quality to it. So that's why you want to have that logo for the trademark and the name of the Neighbor Council. And once you decide on that, stick with it. Don't keep changing it because that's the whole thing about logo. Okay, so I don't think there's much about that other than the fact that for years I've been pushing for the Neighbor Council logo to be registered. Now, by the way, by the first use, the city owns the trademark rights in all the logos, in the name, in all Neighbor Council, under common law. But if we register it, we have the lawyers are unique, have a better way to enforce. Okay, so we'll get some Q&A at the end, and I want to cover very quickly the basic. So if your Neighbor Council wants to have an enhanced level of protection for the logo, you should try to ask our office to register them. And I've done it for some Neighbor Councils already. It's very easy. The only problem I have is I need a credit card. That's the only thing that's keeping me from it. Okay, so that's enough on that. The next bucket I want to cover is the copyrighted material, which would be, like I said, photos, audio, visual, web pages, and anything you think about. Usually you see the circle of copyright, book, people with claim copyright, then that's copyright. There are two sides to it. There's one, we own the copyright, meaning that material is sitting through the neighborhood council created, like your website, your web pages. We the city own the copyright to every single page and the writings on the page. And that's our copyright. So we can protect that if someone else uses it or misuse it without our authorization. Especially second is that when it's other people's copyright, that we want copyrighted materials that we want to use. So let's say if there's some writings on other people's book or even a newspaper article. If you want to take an excerpt, put it on your website or in report, unless it's a line up there, you really need to get a copyright permission. Okay, it's pretty simple. They all done it back and forth, and you have the call it newspaper and boom boom, email done. Thank you. Put it in the file, and that's your copyright license, so to speak. Okay, it's really simple. And the last one. Would be the, let me expound a little bit on that. Let's say if you have a photo of a YouTube video. That's a copyrighted material for the video. You want to get a photo for that. But sometimes what happens is that in the video it contains, let's say, McDonald's watermark, trademark. So it's another person's trademark. So what do? You get permission from the trademark owner, the McDonald's company, to use the trademark in your case, right? At least that's the beginning position. You know, sometimes we don't have to. That's after you consult, our legal office, and then we'll whether you need or not. In some cases you don't. But generally, that's your starting point. You want to say, hey, do I need one? So you get a copyright license to use the video. But also within the video, if you have other people's likeness, faces, or a trademark, you may get the permissions too, right? So remember, how many of you have walked down Venice Walk, or anywhere the filming company would say, hey, we're going to film you here, sign this release. I mean, right? That's basically what they do with it. They want to use the likeness in the content, and they want the permission. That's what it is. They call it release, waiver, doesn't matter. It's basically permission to use the likeness. And same thing with, I'm going to give you a little case. Ben and White has sued, and I think it was a battery company. I forget which one it is. It said, what's the something for the record? Thank you. Yeah. And so I don't know if anyone heard about the case, and they were doing the advertisement and using Ben and White's not face, just the image. With the long gown, turning things, and Ben White sued them. And Ben White won because the case is like, look, everyone knows it's Ben White even if it didn't show the face. So, and the image in the sample was used in a commercial without permission. And so that's a funny thing, kind of, I thought it's funny, in my early days. So the last bucket I want to talk about is the likeness of that's exactly what it is, the likeness, right? So anytime you have people's likeness used in your material, just make sure, that's a reminder, okay? You want to have permission. And let me give you an example to the next point. I was in Washington, D.C., and in one of the new museums, and then the group of people whatnot, and I was just busy taking a picture of the architectural elements of the new museum. I wasn't aware that the little critters were down here. And they were not in my photos. And the custodian and the teachers, they were really protective. Like, no, you can't do this. And I was like, oh, I'm sorry. So when you go and take pictures, just be mindful of that. So, and then once you have that picture, also how it's used. Because there was actually in the top case back a few years ago, a picture was used in the newspaper, which is got more freedom to use certain people's likeness. Because in the 6 o'clock news, they really don't need to get the release or use of your likeness because it's new. And kit was used in a newspaper headline as, I forgot, one camp supporting or against Prop 8. And the model came out really strongly against the newspaper, saying that, you can't use my kid's picture. It was not exactly in the same event or something like that. So because we're public, so be very mindful of that. I think that's all I have to say for now, and then we can take some time for questions. Thank you very much.
You're going to ask questions, but let me just add a couple of things, and then we'll open it up for questions for Phil. Basically, this year, as we're learning, as we are working with our neighborhood councils, and neighborhood councils are really being encouraged to create their brands, so that creating brands, so when you do, whether you're doing your pins, you're doing your t-shirts, that the brand that both represents your neighborhood council, the name itself, as well as your logo that you're putting on your pins, you're putting on your bags, that we're going to be asking you to put in your budget the cost of having us still here use the federal trademark or copyright protection. Because if not, what will happen is somebody else in your community will take your logo and put it on their activity, agenda, or whatever, and then trade off of that. And then, so the public will think it's your neighborhood council that may be putting on this event, that may be selling this particular product. So we're teaming up with you. You contact us. We'll kind of give you an idea generally of how much you should, set aside in your budget for the cost of the registrations. Also, those of you who do, events like concerts and, concerts in the park, movie nights, again, you're using material that we may need to get the permission of if it's a particular movie that you're using, depending on what it is, you should contact us so we can let you know what permissions, if any, are necessary. But this year, we're about trying to help educate you on what requirements are out there, okay? So I know a lot of times people say, well, we've been doing this all the time, and we've been doing this, for the last 10 years. Yes, that's fine. Everybody does their things differently. A lot of times you'll have events, you're co-sponsoring with the park, you're co-sponsoring with the council office, with another nonprofit who may have been taking care of those background logistical matters that you're not aware of. But I know as more neighborhood councils are moving to host, organize, and administer their own events and activities, it's now about making sure that you know what the rules are, what the requirements, what permissions, what licenses, what permissions. So we just ask you, on the front end, if you think it's an idea you want to do, let us work with you on the front end. Also, if you're going to be looking to create a logo, please contact us, because it's very important. If you're going to look to hire somebody to design something for you, or even if you have a member who says, oh, I will create this, we need to talk to Phil so that he can provide the guidance on how to do it the right way, so that you don't have somebody who says, well, wait a minute, that's not yours, I created that, that belongs to me.
Yeah, I think that's a good point, and that's deeper than what else. But then, if you do create any new names or logos, slogans for your programs, anything that is not designed by city employee, then make sure that that person has a certain written documentation agreement with the city or the neighborhood council that the city will own the intellectual property right, and that including the copyright design. Okay. All right. Okay. How much time do we have for Q&A?
We take 2 minutes of questions.
Okay. All right.
I have my hand up first.
Okay. All right. Yes.
Excuse me if this may be redundant.
Oh, can we ask a favor? As you ask questions, it's not required, but it would help us to learn who our clients are, so you would, identify what, if not your name, but at least what neighborhood council you're affiliated with.
From Pacoima. The question I'm asking, and forgive me if this is redundant because we did come in late, but I happen to notice that you have here the art of agenda preparation up on the screen. One of the things that was seriously lacking in our parking pass was where to park. I do think you should have included that to say you enter the parking lot on Los Angeles Street between 1st and 2nd. It took us almost an hour to find that out.
Can I table that question to Lois?
No, wait a second. What you should do, those are logistics of the organizers of this event, so I believe you have a document to critique today, so if you could put that in your comments to turn in to the folks so that
I don't
they'll
believe
know
I
that.
got a critique document.
Huh?
I don't believe I got it.
Yes, it's the yellow at the outside, make sure everybody gets the critique form at the end.
Okay, can I take an announcement? There's a Spanish interpreter here, so anyone needs to service, use the Spanish interpreter. It's over there, so anyone needs to service. Okay, number two, I'm gonna go back and forth.
Si alguien necesita traducción en español, hay un intérprete que está en el salón. Gracias.
Get Lenex the back corner.
Hello, my name is Freddie Kupanemes. I'm from the North Hollywood West Neighborhood Council. You start talking about trademark and release forms. If we were going to take a picture of someone's likeness, would a flyer or a big banner or poster saying once you enter this area, if we take pictures, you're already consenting to that release of likeness?
Normally, that's one way to take care of that. The better way is to get, let's say if you have 5 persons in the production in the PSA of the city, you want to get all the 5 persons to personally sign the release. But if you have 500 people,
Yeah.
then you stick out the sign there, and then you make sure these people still place. Everyone knows it. They enter, they see the term, and you take a picture or save that piece of poster, your file, and kind of document by putting there, and that's probably the best thing.
So that's good enough, right?
Yeah, generally, yes. I will go to the slide.
Yes. Young man.
My call software is neighborhood council. So I gathered from saying there is no fixed fee for trademark. You said it's calls to towns put in our budget, but is there a fixed fee or is it?
I don't want to get too much into the nitty-gritties, but basically, trademark, if you register, number one, I want to make it clear. We already own the trademark right on the law. By registering, we enforce our right. Okay, so to register with the U.S. trademark office in D.C., they generally about 275 to 325, but I will normally use the category that charge $325 per class. It's the more class you register, like let's say I'm having a neighborhood council for a city organization, and then another class I want to register the same mark for outdoor, that's another class. If I want to register the mark for restaurant business, where we provide food, that's another class. We want to sell diapers, that's another class. Okay? Got it? Okay.
So that's what we say, contact us and we'll give you, I would say just allocate like $2,000 and then you work from there based on your name, your mark, and then what classifications that will all fall in. Let me go to the back here, the young man who's here.
My name is Martin Terrones, I'm a stakeholder. If you are part of a neighborhood council who's sort of lagging behind and failed websites, and you yourself as a stakeholder took it upon yourself to register a domain, I'm not going to say the neighborhood council course, but it's .la. Does the city still own it even though it's the abbreviation to the neighborhood council? And do I have some right to update the website based on the information that I want? Do I have to go to the council for permission to update, like what's happening, et cetera?
Well, number one, if for specific legal question, we will direct to the council, because this is the neighborhood advice division, because this is a general discussion. But let me say in general that the city, by law and equity, at least I claim, and I would last position is that even it was misregistered, let's say in domain name under some person's name, eventually I'll get transferred back properly to the city's name. So the city owns that Labor County's domain name. So it can be straightened out, yes.
We're gonna go back over on this side.
The yellow shirt,
Yeah.
yellow shirt, please.
Yeah, our neighborhood council actually calls into the decision. We're talking about, just a little bit ago. We've been using a logo for years, and our neighborhood council never got the copyright for it. It was done by a third-party independent artist, and just volunteered, and it was granted to the council. But, the rights granted were, perpetually exclusive, but non-transferable. So technically, the original artist still owns that copyright, and it's
Correct.
and
And again, their copyright is one bucket, trademarks another bucket. And when we get too much into the details, we'll take it as a legal counsel. But in general, here's what's happening. Unequivocally, the city owns the trademark rights in the logo. And the copyright is another right that's independent from it. And if we, the city, or the neighbor council, have done it right, or can clean up and do it right, and get it copyright also be transferred, that'd be great. If not, we can still use it and enforce it under the trademark law. And that's what we have been using to help enforce your interests when there are unpermitted use of your trademark names.
has the city been operating under the assumption that it owns the copyrights of these things? Because this is the first I've ever heard of it. And I imagine that there are a number of council logos or images that, for which, the city doesn't really have such clear rights, and they put themselves in a difficult position by assuming it does.
Yeah. No, I don't know what the assumption has been made, but I understand that Labor Council is brought forward with a lot of logo and whatnot. So to the best we could protect them, we did using the trademark law, and we have very effectively gone that right. And I don't think, again, I don't know what the individual Labor Councils done and whatnot, but usually I don't see there's not much issue because people who designed it actually wanted their work be used as a logo. And so it's not a conflict, it's a matter of just cleaning up the paperwork.
As I said before, and I've been saying for the last couple of years, is going forward as we're becoming aware of issues, we're trying to help educate all the neighborhood councils on a wide variety of matters. And again, this is one of the areas that we're trying to advise neighborhood councils that if you have logos and whatever, that it's best that if you can register them, that establishes your federal rights. A lot of them will go back to when your first use was. There's paperwork involved. He is the expert, but you will work through us. I'm just going to make a general blanket statement because a lot of neighborhood council people kind of see themselves independent of the city. You're not independent of the city. Everything that you do, everything that you buy, how you spend your money, it's neighborhood council, city of LA. It's one and the same. Everything, you're using city of LA money to conduct your business. So everything that you buy ultimately belongs to the city. It is in the possession of the neighborhood council for the purposes that you're using them for. When individuals for the neighborhood council are through with their service with the neighborhood council, if they have equipment or items or anything in their possession, it should come back to the neighborhood council. Again, we will be working with neighborhood councils, particularly since this election year, and we have a lot of new board members who aren't familiar with a lot of things. So it's about educating and letting everybody know and understand. And then the boards create their own set of rules how they're going to operate. But again, we will provide whatever the guidance that we can to do that.
Comment? Can I, the lady in white, yes.
We're bringing this up to you.
Yes.
Lisa Sargent, Studio City.
Yes, yes.
When this picture of me is taken off our website from this, the FBI contacted
What website, what?
the Studio City Neighborhood Council website. They contacted me. They contacted our president and told him that everything that's on our website is public domain. So what has changed since 2 years ago? The FBI, public domain.
Okay, this is an issue that we'll have to take,
This is fully a question to the
yeah,
neighborhood
forward
council
that
advice.
to your neighborhood
Well,
council.
we
and we'll-
discussed it, it was all discussed with Gary Martinez at the time, too. I'm just trying to understand if
Okay.
something has changed since then, that's the question.
I'm not exactly sure what the advice was back or not, but I would be happy to talk maybe after.
Okay.
But then there will be more of a legal counseling thing.
Okay.
Okay. And again, bear in mind, a lot of people, including FBI and my friends in justice, and I trained them in DC. Non-IT lawyers use terms all over. Public domain is a term of copyright. And sometimes they would sort of mix it with Lexus, they will mix it with the trademark. And sometimes, you get calls like, I want to copyright this thing, it's not copyright, it's a trademark. I want to patent this thing, it's not copyright, it's a trademark. So, but I want to rest assured that, the city government, I have got very good quality from the staff. Well, I came to talk to one night, got a call from the mayor's office, some years ago. I have a copyright issue. Not patent, not copyright, not patent. She's right on copyright. So the quality is very good right now, and we are the first city in North America that has the IP practice group. And so it's, we do the best we can. Okay, we're going
We're gonna take two more questions and we gotta move on. So, Chief, we're gonna take her and then we'll take you next.
We'll say the lady the last one.
Okay, so we'll take three. Young lady here in the front row.
I do two things. I report property meetings, and sometimes neighborhood council does it for themselves. So when a neighborhood council records their own meetings, since it's a public meeting, and then later uses part of that footage, do they still need to require admission or resolution or acknowledgement from the people because of the part of a public meeting and snippets of that meeting opposed to then on a different website with neighborhood council? Do they need to think about that as a part of something within the training or?
I mean, generally, again, we can go into more specifically with council context, okay? Generally, when you report something, like, what's being done, there's a certain right to it. The use of it depends on how it's used. If it's 6 o'clock news, they come in and report it, they don't need copyright, they don't need clearance for a license, they can show it, okay? And they want to commercialize it, or not, then it's a different story. If 6 o'clock news use the same clip, at 6 o'clock, they need to play the license. But if they use it commercially, within the commercial, then they do. Okay, so it's the context within which it's being used. So it's very fact specific. When you have a set of facts, we'll go to our city council's office, we'll check that. Okay, I think this lady is the last one. Yeah.
So a two-part question. We wanted to establish our logo. This is last year. And some of us have been in some beginning, and we had what we call our logo, the black shape, with all the districts included. But the new people didn't want that. So we just put it on the table to supposedly handle this year. We I understood from you today that we should, when we want to do our logo, we should come to you first, so you can give us sort of guidelines as to how to proceed. Is that correct?
I think what she's saying is that whatever business decision you have made, whichever logo you're going to use for whether the design is going to do it from outside, non-city employee, we want to make sure that you have the right form. So the outside designer, it's like a service contract. So you have a contract with outside designer, so they would counsel with capture all the right, there's no dispute at that time.
Okay.
This young man here, and then we gotta move on.
I'm like saying that everything is automatic and we made CLA, as no more creation in the copyright trade, not registry for creation. How can it be without any kind of contract or pseudo contract, the neighborhood council member or volunteer and be able to pay for hire?
That works me for high, but that's what I'm saying. The trademark, the copyright, especially in the terms are very sometimes, interchangeably used, and it's incorrectly used. And you see a lot of website, case of artists and whatnot. Work made for hire is a term for copyright.
Right.
And it's not a trademark. Trademark is best with the first entity that uses it. Because the city of Los Angeles used to the neighbor councils, the names, the neighbor councils, the logo. We, the city of Los Angeles, owns the trademark right in whatever logo the neighbor council decides to use. If you have a person who does a website, a web page design and whatnot for neighbor council, then there's a, let's say there's a web designer that comes in for the portal, the web page design, look at all of that. Then that's exactly what Carmen was saying. Prospectively, you want to make sure that you have the neighbor council contract with the website designer to make sure that the city captures the copyright. Otherwise, you have to remedially, do this, do that, and it just less administratively efficient and more messy. Does that answer the question?
No, really, no.
Okay.
Only about copyright, not about the trademark.
Right.
Only about works made by not only the no contractual relationship. Why do the copyright loan creation? And second question is, how can it be automatically so everything is okay for hire? When it's not.
That depends
It's not
on
open.
that depends on what it is. If you have if a city employee does it by operation of the law, the city owns it, okay, and that's what we call hire. But if again, I'm talking in general that I'm running the risk of too generalizing it. There's some exception, there's some different cases in here, but generally you're correct that if you don't have a contract for a non-city employee to do some service for the city, there could be some issues in the flow of ownership of copyright for whatever that's protected from the copyright. And that's exactly what Tom was saying, that if you have a service with a website designer, for example, we want to make sure that the service, you pay them $5,000, design a website, you want to make sure you own, the city and the neighbor council owns the copyright to it. And then the person does not come back and say, pay me $5,000 every year.
If they get paid with the design, including the logo, why would there be any kind of contract?
Okay, like I said, let's say for a case for the logo, we need to move on. The same logo is protected by two legal interests. One is copyright, one is trademark. Copyright, it depends on how it's done and whatnot. Trademark, unequivocally, because we're the first one to use it for that service. Then we own the trademark rights, the city and the neighboring council. The copyright is another issue. Okay, and that's what you're raising about the work made from high and all that. And then without the clear paperwork, it's just messy. That's what I'm saying.
You need to contact us with your questions,
Yes.
respective of the two of us. Again, I'll give you a public service announcement. Right now, there's an RFQ that is floating out, that has been put out by the Department of Neighborhood Empowerment for webmasters, web designers, all of those folks that you're talking about. So again, going forward, that anyone that neighborhood councils will be required to use one of the companies that will be on this approved list, that will be under contract to the city, and all of the issues that are being raised right now will have been addressed through the contract that they will be a part of for the design, the maintenance, the whatever of whatever social media that neighborhood councils are using. because again, as the mayor was saying this morning, we're now trying to get to the curve, get to that medium line and then get ahead. But we're trying to make sure that we capture and that the ownership is where it should be, and then that neighborhood councils aren't subjected to webmasters or anybody else, shutting down their websites. You taking your logos back, a board member who, may have, designed something, created something when they were a member, they're no longer on the board, and they're saying we no longer have our permission to use this because the paperwork was not done, the right way, on the front end. So again, it's part of the educational process, it's part of the growing process that we have, and we'll be working with you all until we say whatever questions that you have in these areas, either contact me, Central, South. I'm from basically the Hollywood Freeway down to San Pedro, and Lois has everything going the northern and eastern direction. It's kind of how we break up. But we're going to have to move along because we had a whole lot more that we were trying to cover for you guys. A lot of this is just about education and getting that information out so that you can start thinking, knowing, having the triggers to say, hey, we need to contact the city attorney's office for further advice. At this time, I'm going to turn it over to Lois for us to quickly address issues of agenda preparation, and then we will wrap it up with some other FAQ kind of things, and hopefully get you as much information as we can today.
So everybody should have the handout that is available at the back of the room. If you don't, this yellow sheet? No,
It's the PowerPoint. Okay, why don't you have a seat? Phil, pass them out so we can move forward, because we really want to be able to get to answer as many of your questions as we can before the session breaks up. Okay, we're having technical issues, so I will start talking and the PowerPoint will hopefully catch up. Basically, and I think we're going to move even faster because if you have the PowerPoint, you have what we're going to talk about. But basically, what we want everybody to understand going forward, that as the neighborhood council in conducting business, agendas are needed in every general board meeting, special board meeting, standing committee meetings, ad hoc committee meetings. If you have a non-board member on the ad hoc committee, okay, soon there will be in existence the regional grievance panels. That ordinance will be forthcoming hopefully in the next month. And so when those bodies come in, we'll be working with them to determine, well, they'll be Brown Act bodies. Your current grievance panels for your individual neighborhood councils, please contact us and we'll have to advise you kind of on a case-by-case basis when that needs to be served as a Brown Act notice agenda item. The time frames for posting agendas. The more advanced notice you can give of your meetings, the better. The minimum notice requirement under the Brown Act is 72 hours. Okay? But let's err on the side of, plus the earlier you can get it out, if there's an issue in something that you have agendized, where you haven't given enough information, maybe you put a wrong date or wrong time, the earlier you get it out to us, we can check it and you still have time to fix it. If it cannot be fixed within that 72-hour period, you know, your meeting may have to be canceled. So let's try to work with Dunn and our office to make sure that we're getting those notices out. Everybody should be aware that there are new posting, additional posting requirements, a new posting policy that was put out, adopted a few months ago by the Board of Neighborhood Commissioners. If you're not aware of it, please go to the empowerla.org website, click on the link that says Board of Neighborhood Commissioners policy, and then go to their policy link. And you should do that as a general rule anyway, so that everybody knows what policies exist out there that neighborhood councils are bound by, particularly the posting policy in and of itself. Special meetings may be called upon 24 hours notice, and you have to post your notice in a minimum one location that is freely accessible to the public. Also, you should, your local newspaper, radio, or television station that has requested in writing that they want copies of your agendas ahead of time. If you've gotten it, you gotta make sure you get those notices out, okay? And only, and with special meetings, only the business that has been specified in that meeting can be discussed. You can't get in the meeting and say, oh yeah, by the way, we should talk about, you should not do that, okay? Hold that to your next regular meeting, or if it's a matter that needs to be acted upon before your next regular meeting, call another special meeting and let's get that agenda done. Again, whatever questions you have, please work with your NEA or contact our office. You know, we're here to help make sure that, you know, all the, you know, the T's are crossed, I's are dotted, so that you end up, you know, not being able to conduct business because you did not comply with one of the technical requirements, you know, under the Brown Act, under your bylaws, under your standing rules, under the bunk policies, and whatever's required by the plan. There's a lot of different pieces out there. It's all again about knowledge, and that every board member should take it upon themselves to make sure that you know what all of those rules are.
Okay, so when you look at who's responsible for making the agenda, you have to look at the chairperson usually in your neighborhood councils is the person that's usually responsible. Some of your neighborhood councils, it's your executive committee. But as far as for committee agendas, each of your committee chairs should be responsible for making up their agenda for their committees. The committee people should not be dependent on the chair of the neighborhood council to make their agendas and post them for them. They should take that into their own hands and make sure that their agendas are ready and that they are posted in accordance with the bump policies. Remember that the agendas are there to assist the public. They're not, they're just for the fun of it. They're there with specific requirements as to what it is that they are supposed to be provided. So remember that the public has a right to participate in the meetings, and they have a right to know what the business is that's going to be transacted at the meeting. So remember to always respect the rights of the public. And what are those rights? Those rights are they have the right to attend the meetings. They have the right to understand what's on the agenda. So make sure that you're not using acronyms and that your agendas are complete and provide a well enough description of the
item that's going to be transacted. They have the right to record their meetings. So when you have people that come in and they have their video recorders and they want to record, they certainly have the right to come in and record, but you want to make sure that they do it respectfully and so that it's not disruptive of the meeting. The public has the right to receive the materials that are going to be handed out to the board members. They have the right to receive that at the same time that the board members receive it. And they have a right to address the members of the board on the items that are being handled at the meeting. They also have the right to have access to the meeting if they have individual disabilities. Then they should contact you ahead of time, provide reasonable notice that they need accommodations, and then the neighborhood council should do whatever it can to, within reason, to accommodate them. Agendas must be clear and reasonably understood. The Attorney General's office says that the purpose of the agenda is to provide a brief description to inform the members of the public about the subject matter that's going to be considered so they can determine whether they want to participate and come to the meeting or not. So they should be able to look at your agenda, and it should be clear enough that they can say, oh, this is an issue that I want to be heard on, and this is what may or may not happen at the meeting, and decide if they want to come, or if it's okay for them to not come because they know specifically that their issue is not going to be dealt with. That is also contained in the government code.
I go back to school teacher phase, apply the 5 W's to your agendas, and if you can ask the question and answer the question based on, the who, what, why, how, rule, then usually at that point, you've given enough information to the public so that they know, what it's about, how it's going to be addressed, whether it's a yes or no, if it's an expenditure of money, who's seeking the money, how much it's going to be, what's it for, what's the public purpose, what's the public benefit. You want to make sure that you kind of touch upon those things so again, the public who's looking at your agenda, knows that, and they can say, yes, I want to come to be heard on it, or again, it's not a big issue, you guys can go ahead and do what you're going to do.
The government code says that it can be a brief description not to exceed 20 words, but there's nothing that says that you can't make it more than a 20-word description. If you have, if you have to have a short paragraph on what is going to be transacted, that's okay too. It's better to err on the side of giving more information to allow the members of the public to know what your business is that you're going to transact, rather than to say something brief and short that they're not going to understand, like, motion to give money. That's not going to be sufficient enough to describe what it's for, who it's going to, what the form of the request is going to be, and so you need to be more specific on that. So the commission has decided, along with the Brown Act, what kind of notice needs to be given for the public meeting. We've described that already. We want to make sure that the agenda item is not misleading and that it doesn't say something, it doesn't make the members of the public think that you don't want to sneak something in because at that point, if they haven't been sufficiently advised of what is going to be transacted, and then you actually do make a decision on something, then you could risk having perhaps a Brown Act challenge and end up having to redo whatever that item was. Make sure that when you post your agendas, that you post any related items that are going to accompany your agenda, so that they know. For instance, if you have your minutes, you can post a copy of the draft minutes so that they know what the minutes are going to say, and they can be prepared to comment on them. If you have additional materials such as a link or information on a land use issue, you want to provide that information at least as a link, a hyperlink on your agenda, so that they can click to it and get more information on the subject and the item that's going to be discussed. Let's talk about the posting requirements from the commission. The commission has established a new posting policy that everybody should be familiar with by now. They have changed the requirement from 5 posting places to 1 single posting place that's Brown Act compliant. But remember that if you want to have that 1 posting place, then you need to make sure that you let Don know where that 1 posting place is going to be. There are other conditions that accompany whether it's going to be the 1 posting place. The neighborhood council has to also post it on their webpage or their website. So if you don't have the webpage, then you're still going to have to comply with the posting at the 5 different locations.
So then it would be 1 web page and 1 other alternate physical location. Is that correct?
That's correct.
Am I moving the question?
Well, we have 10 minutes, so we can actually just go to questions, and you have the materials, and if anybody has any questions, we can go ahead with the questions.
We take 2 minutes before we go to questions, and then I'm gonna go. Everybody, when doing your agendas, when conducting your meetings, we have handouts about how to conduct meetings. Every board member should make sure they familiarize themselves either with the Rockford Rules of Order or the Rosenberg's Rules of Order. Rosenberg is much more simpler to the point, and basically a lot of issues that come up in neighborhood, what's going on in meetings, with how motions are made, how motions are tabled, your agendas, how to maintain control of your meetings, how to move things along. Those are all parliamentary type items. Presidents in particular should know the rules in and out, but I recommend that all board members know the rules, because then that makes your life so much easier. When you know the rules, you'll know that it's procedural stuff, not necessarily legal issues. We come back to help, but so much is, your bylaws. Does your bylaws address all the issues of how you want to operate your neighborhood council? Does your standing rules, fill in the blanks for your bylaws? Does you have a, code of conduct, code of civility? All of those things help address a lot of reoccurring issues within your neighborhood councils, and the more clarity you have in your written rules, takes out, well, what did they mean? Well, how did they use their purpose? So how should we be doing this? You have your roadmap. That's what all those assorted rules and things that you guys have help you do. We're available if you don't have them. We have templates, we have best practices that we are more than willing to share with you based on our knowledge and experience of how the other neighborhood councils, operate. So on that note, I'm stopping, we take your questions. Let's take somebody, the young lady standing in the back.
Today, everybody, my name is Vanessa May. I'm from the Clifton Trail Education Council. We had an issue come up regarding the new posting requirements. We're operating under the 5 posting requirements now, and we do have a website, and we wanted to use the new posting requirements. Our president said we cannot use those because it's not within our bylaws.
Well, the bulk hierarchy of the rules, federal law, state law, municipal law, commission policy, then the plan, which is part of the administrative code, municipal law, then the plan, done policies, because they have an oversight over neighborhood councils, bulk policies, then your bylaws, your standing rules, and then you can fall down on your Rosenberg or Robert Rules of Order to fill in the blanks. So the bulk policies currently trump your bylaws.
Okay, thank you.
That issue is going to depend on what the neighborhood council wants to do. If your neighborhood council decides that it wants to do the 5 posting places, then they can do that. If they want to change to one physical location, then they just need to make a bylaws change and have the bylaws conform. But you first need to make sure that you let them know where that one posting place is going to be.
And that's a board decision, that's not an individual decision. So the board needs to agendize and discuss which part of the policy that they want to follow. But again, it's the board, not individuals, dictate how you guys operate. Hold on, let me go.
I don't think she was done.
Oh, no, so for clarification purposes, we can go ahead and vote to have it at the one spot and then work to get it into the bylaw.
The board votes which part of the bulk policy that they want to choose. The moratorium on bylaw amendments are lifted as of now, so this is the time that you want to review your entire bylaws and tweak it in the ways that you want it to be tweaked. Okay. So, over your picture. Yeah.
I want to know whether or not this statement on an agenda is, okay. It says, motions, discussions, and a vote may be taken on all items posted on the agenda. That could mean call to order, reports from cities, federal, state officials, guest speakers, officer reports, all these things that don't give any description. Public comment, we already know we can't do that. I have issues about it, and this is being done on a continuing basis, and actually a presentation suddenly ended up having the board take a vote of where the public had no clue. I don't even think the board members had a clue that they were going to be taking a vote on something. My question is, shouldn't they at least vote and next to the items that they are going to take and possibly take a vote? Note that next to it, because obviously you're not taking a vote on call to order. Or,
Okay, let me cut you off. Again, neighborhood councils have a lot of leeway right now on how they do their suggested templates for following. As to that particular neighborhood council, I would need to speak offline on that, so we will talk offline because
That's a specific question.
that's a specific question and I cannot go into that here in public forum. Definitely in the black.
Sharon, East Hollywood neighborhood council. You said that the materials should be available like minutes, something like that, that you're planning to approve at your next meeting.
Yes.
Do they need to be posted, or can you just say the minutes, if you'd like to review them, are available on our website here?
On your agenda, there should be a paragraph that will state exactly where the materials are available for viewing. Neighborhood councils who have offices that are maintained, definitely whatever those materials are that are going to be at the meeting should be there in a binder. I recommend if you have a website, this is the best practice. Cuts down a whole lot of work. That if you have the draft minutes, put draft across the document so that people don't know. Post it as a link to that part of the agenda on your website. So that way, when they're looking at your agenda online, they click on it and it goes directly to the document. Any other documents that you have, if you can post them somewhere on your website in appropriate category, that makes life easier.
But my question was more specifically, I realize I can post the agenda in one physical location. Do I also need to physically?
No, the documents themselves do not have to be posted with the agenda. They just have to be made available for viewing. And again, my recommendation is, as we try to go green, the more stuff that you can get put up on your website, the more stuff you can get put up on your website, you cut down on Public Record Act requests and everything else. Yes, sir.
What if we have an executive committee is making an incorrect statement on the agenda, and they refuse to change?
That's a specific question, not an individual neighborhood council. We're not giving legal advice right now. We are just trying to give an overview of the best way to do your agenda.
And again, I would recommend familiarize yourself with parliamentary procedure, and it addresses those issues about agendas and all of that. Young man right here.
With the neighborhood councils that do seek to provide posting locations, they don't identify, should identify the transition one, because it's public, they don't identify the gun, and so it could be showcased, or it could be one of the five.
Actually, they should identify on their agendas where the posting locations are. That should be written on the agenda itself.
Have it at one location, they still qualify to have meetings because they've done one visit.
Did you familiarize yourself with the new policy on postings and it addresses that issue? Young man in the back. No, right there. I'm sorry, second row.
Yeah, I wanted to clarify the data there on the west, because to my mind, you guys said diametrically opposed things on that. In terms of using the new posting system, you claim that the law regulation overrides everything, so therefore the neighborhood council can just go ahead and do it. But you're insisting that it needs a bylaw change.
I'm not insisting.
She said you could.
Hey, I'm talking about.
No, let me clarify. No. What happens is when there's a change and there is an inconsistency in a bylaw based on new policy, they call it an overlay. And so until a bylaw can go through the official whatever to come in line with the new policy. But again, it's still a board action as to, because the policy, if you look at it, still provides for either or situation. But
So my understanding is that a simple vote of the board to go to the new policy is sufficient.
What would happen in that case would be then the board could subject itself to having a grievance filed. Then you have to go through the motions of dealing with the grievance for not following your bylaws, only to have it come out with a recommendation that you change your bylaws. So
then the appropriate way would be not to use these systems for the bylaw.
it's up to the board.
But you must learn, first off, read the policy, because the policy has two options in it. And one of those options usually covers what's currently in your bylaws.
Well, yes,
So
if you wanted to use the new option, my understanding is that you really can't use it until you change your bylaws. Is that what you're saying?
You can use it.
let's talk to you offline, because you're creating confusion. Okay, we've got a young lady right here in the black.
Anita,
Contact, which neighborhood council are you with? Okay, contact Lois, her information is on the thing, and she will provide you with.
No, do this thing, we're going to change place that they were designating wasn't workable, so it didn't matter in that sense. But is there any special, since this is a bylaws issue, are we required to go through a special process to bring bylaws changes to the floor of the neighborhood council for a vote? Does it have to be a designated time to do that?
Talk to your NEA. Your NEA, your DUNN representative will advise you on how to go through the bylaw amendment process, because there's a whole process that you go through. So,
But I think anybody here will be able to do it. So we need to have a special process to actually amend the bylaws or change them, rather than people piecemeal making proposals at particular meetings.
Some bylaws have standing bylaw committees, others create ad hoc committees. You need to create a committee to review overall, don't piecemeal it. Look at your overall bylaws, and then go through the process, talk to your NEA, contact us, and we'll kind of help guide you through that process. Thank you very much.